Hello, I'm United Nations Secretary General Ban Ki-moon. The world's oceans cover about 70% of our planet. They have inspired many people's imaginations. Many films have been made about adventures at sea, pirates, and even sea monsters. This documentary tells a different dramatic story. The story of how the countries from around the world came together to create the United Nations Convention on the Law of the Sea. For a fisherman, for a shipping company, for billions of people who depend on marine resources to survive, this convention is a matter of sink or swim. 2012 marks exactly 30 years since the convention opened for signature. Today, more than 160 countries are party to the convention. They follow its rules and work toward its goals. They ensure that every day the rule of law on the world's oceans and seas is respected. This is a major achievement for international law. You are about to learn how the oceans and seas were governed before and after the convention was born. I hope many more governments will recognize this convention's importance, and I hope they will become parties to it in this special anniversary year. Now let us learn what got us to this point and how we can set sail for a better future.
The oceans have long been viewed by societies as a wide-open free space, a vast frontier associated with adventure and mystery. In the 17th century, nations formalized this viewpoint into the freedom of the seas doctrine. A principle was put forth essentially limiting national rights and jurisdiction over the oceans to a narrow belt of sea surrounding a nation's coastline. The remainder of the seas was proclaimed to be free to all and belonging to none. This is the story of how the United Nations Convention on the Law of the Sea, UNCLOS, an international agreement, defines the rights and responsibilities of nations in their use of the world's oceans. But what was it like before the adoption of UNCLOS? How far out to sea could a country claim territorial jurisdiction? The world was left with a chaotic situation. How could nations claim a 3, 4, 10, 12 or 200-mile territorial sea limit? By the 20th century, the ocean's resources were increasingly used for economic purposes. Nations made greater and greater claims on offshore resources. From oil, tin and diamonds to gravel and food, the resources of the sea are enormous. But the depletion of fishing stocks in coastal waters and the adjacent seas by long-distance fishing fleets began to cause growing concern. Fleet after fleet, net after net, huge hauls of fish were virtually unrestrained. Tin had been mined in the shallow waters off Thailand and Indonesia. Potato-shaped nodules found almost a century earlier, lying on the seabed some 5 kilometers below, were attracting increased interest because of their metal content. Waste from transport ships and oil tankers carrying noxious cargoes began to pile up on sea routes, spreading pollution across the globe. Adding to the problems were other developments. Deep-sea drilling for oil, which moved further and further from the land and deeper into the continental bedrock. Rising tension between coastal nations and distant water fishermen who competed for harvests and resources. The increased presence of conflicting maritime naval powers threatened to transform the oceans into a global arena for conflict and instability. Conflicting claims multiplied. Nations wanted to expand their territorial rights, and disputes broke out over how to carve up the continental shelf. In the United States, President Harry Truman directly challenged the freedom of the seas doctrine in 1945, by extending the US rights to a wider band covering all of the resources on the continental shelf, including oil, gas, and minerals. Many nations followed Truman's lead and also extended their sovereign national rights to the seas. The oceans generated a multitude of claims and counterclaims over ocean space, resources, and sovereignty. The sea was now becoming the nucleus of world conflicts. Something had to be done to promote stability, the management of ocean resources, and the many conflicting claims. In 1956, the United Nations held its first conference on the law of the sea in Geneva, Switzerland. It resulted in 4 treaties in 1958. Although the convention was considered a success, it left open the important issue of the breadth of territorial waters. In 1960, the United Nations held the second conference on the law of the sea, UNCLOS II, a 6-week Geneva conference. Developing nations participated only as clients, allies, or dependents of the United States or the Soviet Union, and it didn't result in any new agreements. In 1967, the United Nations Third Conference took place in New York. Arvid Pardo, a Maltese diplomat, is best known as the father of the Law of the Sea Conference. During a stirring speech in September 1967 at the UN General Assembly, he proposed that the bounty of the sea should be considered the common heritage of mankind. His vision led to the authorization of the Third UN Conference on the Law of the Sea, which convened in 1970 to draft a constitution for the world's oceans. The United Nations International Seabed Committee was formed after much preparation. After 9 years of negotiations, with more than 160 nations participating, the conference ended in 1982 by successfully agreeing to a new UN convention. This United Nations Convention on the Law of the Sea, UNCLOS, was an unprecedented attempt by the international community to regulate all aspects and resources of the sea, as well as uses of the world's oceans, to bring a stable order to mankind's very source of life. From these meetings, a comprehensive treaty was drafted. Here are a few of the issues covered by the convention. 1. Navigation rights. 2. Setting limits to states' maritime zones. 3. The continental shelf. 4. Deep-sea mining. 5. Protection of the marine environment. 6. Marine scientific research. 7. A binding procedure for settling disputes. The treaty established legal principles governing ocean space, its uses and resources. UNCLOS also set up a binding procedure for settling disputes between nations through the International Tribunal for the Law of the Sea. The tribunal has the power to settle disputes between states parties. With its seat in Hamburg, Germany, the International Tribunal for the Law of the Sea is an independent judicial body established by UNCLOS to adjudicate disputes arising out of the interpretation and application of the Convention. The tribunal is composed of 21 independent members, elected from among persons enjoying the highest reputation for fairness and integrity and of recognized competence in the field of the law of the sea. Nations could now take other nations to court over perceived violations of the Convention. The second international organization established by UNCLOS is the International Seabed Authority. Based in Kingston, Jamaica, was established to organize and control all mineral-related activities in the international seabed area beyond the limits of national jurisdiction, an area underlying most of the world's oceans. The Commission on the Limits of the Continental Shelf is composed of 21 members who are experts in geology, geophysics, or hydrography. States parties to the convention elect them from among their nationals, but members serve in their personal capacity. The Commission makes recommendations on the outer limits of the continental shelf beyond 200 miles. Although each coastal state establishes its own continental shelf limits, only limits based on the recommendations of the Commission are final and binding. Because of the United Nations Convention on the Law of the Sea, nations' coastal waters, together with the seabed over which a state claims sovereignty, were defined. Territorial waters is water over which a state has jurisdiction. Up to 12 nautical miles from its baseline, including internal waters and territorial sea, the contiguous zone up to 24 nautical miles, the exclusive economic zone up to 200 miles, and the outer limits of a country's continental shelf up to 350 miles. There are currently 162 parties to UNCLOS, including the European Union.
We hold the future in our hands.
A number of duties fall upon the Secretary-General of the United Nations. These include the depositing of charts and coordinates, showing the maritime limits of coastal states, and providing substantive servicing to the Commission on the Limits of the Continental Shelf, which has also been established by UNCLOS. The Secretary-General is also called upon to convene the annual meetings of states parties to UNCLOS. The Convention has withstood the test of time and will continue to be the governing treaty dealing with all oceans and seas issues, a true constitution for the oceans, for all states, and for the future as well.
My name is Patricia O'Brien, and I'm the legal counsel of the United Nations. As illustrated in the film that you've just watched, the oceans play a significant role, not only for our planet, but also in the lives of people like you and me. We all benefit from the oceans in a variety of ways. The UN Convention on the Law of the Sea, known as UNCLOS, which defines the rights and obligations of states in their use of the oceans, is 30 years old this year. UNCLOS has proven to be a remarkable treaty in the service of states. It has helped them to plan a course for the well-being of our oceans and seas. My office is very proud to count UNCLOS among the many treaties deposited with the Secretary-General of the United Nations. I should like to lend my voice to that of many others, marking and celebrating the 30th anniversary of UNCLOS, a treaty that has stood the test of time. Thank you.